Yeah, and you would have also heard about pharmacy, which is you can order medical your medicines online, which will be delivered to those doors. These are all these startups which are very famous in India, and these are required because without these startups, we will not be able to employ uh, everybody who is coming out of the college. So if we are having a startup, what we will be able to generate employment, and we will be able to give employment to some of the people who are coming out of the college, for whom the normal corporates are not able to provide employment, whether it is government job or corporate job. The organized sector is not able to absorb all the people who are coming out of the college. We are not able to generate employment. So we should be having skills to stand up on our own. We have to create jobs and give jobs to the others. That is what we are looking at. And skill development is the key for this. And that's what the present government is insisting and emphasizing. And if you come to the startups, when you have an idea of a startup, what you can do is there are banks which will be helping us out in starting our startups. If we are talking about banks, there are banks can help you out in the form of your term loan or your working capital or even non-fund based funding. Term loans is something which is given to any startup or anyone who wants to start any an idea. But the term loan is given for fixed assets, whether it is land and building, plant and machinery, and all. So, term loan is given not only for the new startups, even if you are having a startup which is existing one, if you want to go for expansion or modernization, or if you want to diversify, for all the things, the banks will be supporting you in financing the startups. And whatever working capital is required, working capital can be given as a cash credit or an overdraft facility. So term loan can be given for the land and building, working capital can be given for your cash flows. And apart from this, even non-fund based funding can also be done. Non-fund based in the form of bank guarantees and letter of credit wherever it is required. And banks, they are the interest rate and the security which is taken by the banks. It differs from bank to bank, and it depends on the policy of the bank which where we are going. So the need of the hour, as I have already said, is the startups which are very much required, and that's the future of where we should be looking at. That is skill development, and after skill development, through our entrepreneurial skills, we should be able to start a startup. And Manan sir will take you through the whole session. He will be delivering on IPR, and I wish all the participants take maximum advantage of the opportunity, as he is an intellectual par excellence, and he has been one of the stalwarts of the institute. And I request all the participants to make maximum use of the opportunity. Thank you.
So thank you, sir. Thank you for giving good words from your end. So hope we will reach the participants'
Thank you, Ramesh garu.
expectations. Thank you, sir. Thank you. So hope we will reach the participants' expectations, and we have such an eminent speaker with us and having a vast experience in the field of IP and as well as also the in education field. Now I would like to invite the today's speaker, Professor B. Manan sir, so, professor and IP consultant, professor in Department of ECE, Gates Institute of Technology, Gutti Anantapuram, Andhra Pradesh. So I heartily welcome you, sir, to today's session. So now I would like to start the session, sir.
Shall I start?
Sir, Manan sir. So please,
Yeah,
please
shall I
start, sir. Please
start?
start the session. Yes, sir.
Okay. Good morning, Ladies and gentlemen, to all the participants, I welcome to this session on intellectual property rights and intellectual property management for startups. Thank you very much for giving an introduction, and thank you for all your help in organizing this. Mr. Anand, our Chief Administrative Officer, and Dr. Ramesh, our MBA Department Professor. I thank all of you, and let us proceed with this topic. IP rights, that is intellectual property and intellectual property rights, are intermixingly used. We generally don't create or observe a difference between these two words, but they are quite different in the sense that one is called intellectual property itself and the other one is the rights conferred on the intellectual property. And it is the most neglected area in Indian scene, at least I have seen. And especially for startups, people don't know where to start in terms of intellectual property and intellectual property rights. And we end up burning our fingers in the sense that it can work as a double-edged sword, as they say. So it can either cut you yourself, will be cut without your knowledge, or you can cut any big or small companies who are trying to take over your market share or compete in the market with you and try to eliminate you from the market. These are very important aspects of any startup, because so many startup have vanished from the scene because of negligence in the intellectual property rights area. So we want to caution you on what are the things we can follow and what are things we should not do in terms of intellectual property and intellectual property rights. These are the following topics in which we are going to cover this entire gamut of intellectual property rights, which is it cannot be so much in detail. It cannot be covered in time given, a time of window of 1.5 hours, but we will try to do justice to the maximum extent possible, because it is taught as a one full semester course, or it can even be taught as a 1 week course or 2 days course. At least one full day may be required to understand a little bit of intellectual property and partially to uh, get some idea and then proceed with caution in the area of intellectual property. But we will try to do justice, and then you can also clarify some of your doubts at the end of this session. In between also you may ask some doubts, but I am of the opinion that so many things can be covered in the process of proceedings itself, and then we can keep all the questions standby till the end of the session, so that you can answer most of the questions. You will get answered during the process of this session, and a few questions which you can reserve for end of the session, and at that time I can cover all the remaining topics which are of interest to you or which have not been covered in the course of this session. So we will go one by one. It's about intellectual property as such. From the beginning, we will start defining what is intellectual property and what are intellectual property rights, and different categories of IP. They are intermixingly used. Once again, people don't distinguish between copyrights, trademarks, and patents. They are all under the same umbrella term of intellectual property and intellectual property rights, but they are all distinctly different, and they are all different different aspects of protection given to different aspects of intellectual property themselves. So we will go through the different categories, and what I think the screen share is out of. Is the screen share still visible? Hello?
No, sir.
Thank you. Screen share is not visible. I will
No, sir.
have
No,
to.
sir.
No. It says it's still visible to others. Check to resume or cancel your resume presentation. Okay. There was a disturbance. Yeah. So IP policy and strategy, which is very much required for a company which can be a big or small company. It is the same for all the companies which are big or small. So we have to take precautions while creating an intellectual property, while making policies on intellectual property, and while making a strategy for a procedure or process during the course of time, whenever you are developing a product or whenever you are providing services to people or public, whenever you are getting into the market, that time, what all the policies to be framed and how a strategy should be formed at the time of starting a company in the intellectual property area. That is our focus and concentration for today's this session. And then we will see how intellectual property can make a difference in your business process itself. And then we will also say some things about how to create intellectual property rights or intellectual property itself. And then we can benefit from the intellectual property in a number of ways. How to protect them is one question to be answered, and the other one is how to make use of the protected intellectual property and make some monetization possible. That is, whenever you are having intellectual property, having it is not sufficient unless you take the maximum benefit out of the intellectual property. So what are the various types of benefits which we can gather or which we can accrue out of the protected intellectual property? That will also be dealt in this session. Then we will go ahead with some conclusion and concluding remarks. After that, we will leave the floor open for a few minutes for questions and answers. Let us go one by one into this topic. Let us start with what is an introduction to intellectual property. What is in any subject, if you are introduced, all these topics or all these questions have to be answered first. What, how, and when, and also how to go about doing all these processes. So this, in a nutshell, what is intellectual property? That is intellectual property rights. Let us talk about it. It is the rights awarded by the society in general, government in particular. That is, the society started the need and the government stepped in and provided the protection or provided the rights to individuals or organizations so that they can get some benefit over the intellectual property created by them, which are intangible assets. Intangible means they are not physical property like you see on movable or immovable properties which you are used to. For example, cars and land holdings, these are all tangible assets which you can see, gold and other type of tangible assets you are aware of. But these are known as intangible assets when you talk about intellectual property. They are basically creations of human intellect. That is the definition. These are the outcome of human intellectual creations. Intellectual creations are producing intellectual property, and government is protecting it, and it is allowing you to take your rights and then enforce your rights on others using your product or your intellectual property without permission. If somebody uses, you can ask for compensation or royalty or licensing income. All these are different forms of the benefits which you are going to get. So what are the creations? They are some of the creative works like inventions, literary and artistic works. These are all different categories, and these can be protected by government intervention and also by legislation or act of parliament, which has been already going on, and they keep on revising from time to time whenever a need arises, whenever the representations from the industry goes to the government, and that time they will amend the rules and regulations, amend the Act of Parliament itself to increase the effectiveness of protection. And symbols, names, and images are coming under trademarks, and then designs or the appearance of a product in the front appearance of the product also can be protected, and these are all having value in business and commerce. So this intellectual property rights is a conglomeration of 3-4 different subjects or different disciplines getting together to create value for the human being and the society as a whole. What are these 3-4 different disciplines? One is technology, the second is creativity, third is commerce, fourth is business, and fifth is legal. Legal framework is common for all these things. They are standing on a legal framework, and legal proceedings can be initiated against those who are not falling in line with the rules and regulations of the intellectual property rights. So they give the creator can enforce his rights, and he or she can prevent others from making unauthorized use. That means without the permission of the creator, without the permission of the owner of the intellectual property, nobody can use the intellectual property for their benefit or for making some business or commercial advantage out of the intellectual property which you own. Others cannot use it, and it is also generally provided for a limited period. It is not for an indefinite period, but there are some rules, some exceptions to the rules. We will come to that subsequently. So it is generally understood that it is for a limited period. Then there are two major categories of intellectual property, which are industrial property in one arm, and the other arm we have this artistic and literary property, are generally known as the individual's rights or author's rights. Whenever authors are creating some things like writing a book or rendering a music composition or singing a song, all these things are known as author's rights, and they are also artistic in nature. They are mostly confined to artistic and literary kind of products. So we will go through them in detail. So in a nutshell, what we understand by intellectual property, it is basically a creation coming out of the minds of people, minds of artists, or minds of the industrial workers, and the minds of scientists, the minds of researchers, inventors. All these people create intellectual property, and it is giving an exclusive right in the sense that it is excluding others from using it. It doesn't provide full rights only to the owner, but these rights are exclusive in the sense that others are excluded from using it. So there is a difference in the legal term between total rights and exclusive rights. It's only giving you the rights so as to exclude others from using it. So these things will be clear when we talk about infringement. We will discuss this a little bit more there. And these rights are all territorial in nature. Territorial means within the confines or the boundaries of a particular country. So it is sometimes even confined to a region also. That also we will see. Sometimes it is the regional rights, sometimes it is national rights or within the geographies of a particular nation or nations. For example, in European scene, it is a European patent issued, and in there is nothing like global patent or global rights issued for any kind of intellectual property, unless there are always some exceptions. There are always some ifs and buts. If it is going through a particular direction and then it is registered in that particular direction with that particular provision, then you can enforce it in global scene. For example, trademarks can be enforced in a global scene by going through the Madrid protocol way of registering a trademark. So these are some of the things are basically within the confines of a particular country. For example, patents are still within a particular country and which cannot be exercised universally or in a global scale. Patents are still not available as a global patent. If somebody says world patent, you can chew it off because there is nothing called world patent. People misuse the term called global patent or world patent, which is actually a publication provided by World Intellectual Property Organization at Geneva, stationed at Geneva, which is under the United Nations organization. And it is only providing a publication for World Intellectual Property Rights Organization's publication. As a publication only, it is available and it is not as a right or not a granted patent. People mistake it as a world patent and then they advertise and misuse the term world patent. There is nothing called world patent. The patents are all confined to a particular country only as on date. And it will never happen in the next maybe 10 years or 20 years. It is a small, slow procedure which is a first step taken by the World Intellectual Property in providing a publication, and it is not providing a world patent as it is as of now. Then this one I will go into some form of what is called categories of intellectual property. I will go into the full screen mode. Are you able to see the full screen, Dr. Ramesh?
Sir, screen is visible, sir.
Screen is visible. So I will go ahead with the industrial property which I highlighted earlier. There are two major categories. Industrial property. This thing started at the time of Industrial Revolution, the 17th and 18th century, when the Industrial Revolution was active. Renaissance period in Europe and US. A lot of industries have come up and they have started mass manufacturing, large scale manufacturing of various goods and services. For example, let us say bulbs were manufactured, some motors were manufactured, electrical motors were manufactured, and they were all confined to a particular industry. They were trying to specialize in that particular product or service, and they were trying to protect themselves and protect from others copying their process and the procedure of making such goods. So these industrial houses, which are big companies, have approached the government and they wanted protection for their processes. Then the industrial property as a whole was born in these formats like patents, trademarks, designs, and trade secrets. What are these things? Let us see patents. Patents are nothing but an invention protected by a description. An invention is described in the form of a patent publication, and the patent publication gets granted due examination by a patent office of a particular government. So the governments will be responsible for granting patents through their patent office. So what you as an inventor do is to write the detailed invention. What is an invention? Invention as such is a problem to a particular solution, a solution to a particular problem. So you have to find the problem, solve the problem by technical means, then invention is born. Invention, the requirement or necessity is the mother of invention. So you have to find a necessity, either it is in the form of human necessities or in the form of industrial requirements. For example, if you want to mass manufacture certain goods and services, the things you want to set up and what are the problems you face at every stage of setting up an industrial establishment. In a technical sense, all the technology you are providing to solve problems and which are provided for the first time and also for the entire industry to take care of, make use of your solution. It should be an industrially applicable solution. So these are four major requirements which have to be met before you patent. Which have to be novel. That is first time you are doing novels as than the past. Either in the form of patent or the form of scientific
public product itself is available to the public already, then you cannot patent. So now it's very important for establishing invention patent. It is granting the invention, granting it requires novelty and also industrially applicable step. That is industrially applicable industry. That is because to be proved before you get a patent granted. Then also required to be explained in detail so that everybody knows what you are exactly doing and how the problem is being solved. And this should be who is interested in subject or who is
having an average graduate level knowledge of the subject should be able to reproduce the entire invention by going through your patent description, and then they are able to rebuild the invention in their own facility or their own setup. They can industrially rebuild the invention. So that much of description you have to provide. That is also one of the requirements of getting a patent granted by the patent office. So the patent office goes through an examination procedure and then grants a patent. Then the patents have to be renewed for every year for a period of 20 years in general. For all the countries, it is restricted to a limit of 20 years, and you cannot get it extended at any cost. So it has to be within 20 years. You have to exploit the patent and get maximum benefit out of the patent. And every year you have to pay the renewal fee and then get it renewed at the patent office. Then we come to this set of industrial property called trademarks. Trademarks, you are aware that there are a large number of trademarks which are symbols, names, colors, color combinations, sometimes even music, smell, all sorts of unique things, symbols and names which are connecting the products with the company, connecting the products with the name of the company or with the symbol. By looking at the symbol, you are able to identify the product, and it is also attributing or contributing to the brand value of a company. So only the brand is established and the brand is having a good impression among the minds of the people, that is, a goodwill is created. So you are ready to buy the goods and services of the company because of its established brand value. So brand value is very important in introducing new products and services, and also keeping your products and services dominant in the market. So you can have a large market share when you have a good brand. And the good brand is built over a period of time by using the correct trademark and also the value of goods and services which you are creating. It gives some kind of impression to the public in the sense that the goods are valuable, robust, reliable, and the after-sales service is good, and various other factors are contributing to building up a brand. So first and foremost thing is to establish a trademark and register a trademark, and trademarks can be renewed every 10 years indefinitely. As long as the company exists or the company wants it to be renewed. Trademarks are not only for the name of the company, it is also for the products of the company, and it is also for taglines such as just do it for Nike. We have a tagline which is having a gist of what it is meant for. That is, the products of the company is having a tagline which will be connected to the products and which will also be very succinct and then very interesting to catch. It is a catchword which can be used for, in addition to trademark, we will have a tagline for the company. This is also registered as a trademark. Then we have design patents, which are also called the somewhat like patents, but they will only be protecting only the appearance of the product, the frontline appearance of the product, like arrangement of knobs and controls on the face of a TV, let us say, either on the face of a electronic gadget or on a dashboard of a car, or the front appearance of the car itself. For example, the twin radiator design of BMW, that is also protected by industrial design. These are non-technical in nature, and they are actually aesthetically pleasing appearance. That is, they are contributing to the value in terms of giving a good appearance and pleasing appearance. These things can be protected only by submitting the drawings, and no need for any description. They can submit the drawings and the appearance, and these things can be protected as a separate design of patents by the same patent office. There will be a different section department handling this patents of design. Then we have a number of trade secrets which you don't want to publish or protect, and you can keep trade secret within the company, which will be known only to a few people who are only at the top position of the company, or the directors, partners, such people who can remember or can even write it down and keep it under their custody, and two, three of them get together. For example, the secret formula of Coca-Cola is still considered to be a trade secret, which will be known to only two or three directors, top people of the company, and that will be kept as secret. And there is no protection as such. But if the trade secret is stolen, the person who is stealing it, or the thief, can be punished for stealing the trade secret by existing rules like criminal proceedings. For example, it can be coming under the unbecoming conduct, or breach of trust, breach of privilege. All such clauses can be applied, and trade secrets can be protected. And we have already seen something about copyright, which are about the individual's works and creations of individuals, not necessarily individuals' creations. For example, a movie is created by a large number of technicians put together, and they are contributing to the creativity of a movie, or a song, or a composition of music. A music director is there, and there are a number of artists who are playing various musical instruments to generate or create a particular song or a piece of music. Everything can be protected by copyrights. Basic requirement is that they should be having some amount of ownership has to be proven, and then it need not be registered at all, but for the sake of enforcement and for the sake of legal requirements, it is always advisable to register it in a copyright office. There is a copyright office in New Delhi by the government of India. There are 4 patent offices in 4 major cities of India. They are located at Chennai, Bombay, New Delhi, and Kolkata for patent offices for patents. Whereas there is only a single copyright office at New Delhi, which is providing the protection of copyrights and granting copyrights to individuals or organizations which are generating such things such as music, movies, books, or any form of artistic expressions. So it need not be a new idea or new technology as such, because new ideas and new technologies can be protected by patents. But the form of expression and the form of rendering of a song, or form of a creation of a piece of music, sculpture, painting, all these things are copyright protected. And these things have to be submitted to the patent office or copyrights office, and then you have to get the copyrights granted. they will check for originality, and they will check to a large extent that it is your work, is not a copy of somebody else's work. So some amount of search will be conducted, and then it will be established that it is novel. At least for copyrights, it has to be original, and it cannot be resembling others' works. So that is how the copyrights are granted, and copyrights are also for a period of till the owner of the copyright is alive. It is given to him or her, and also after the death of the owner, it is valid for 60 to 70 years, depending upon the country. For example, in India, it is 60 years after the death of the owner of the copyright. It can be bequeathed, or it can be subsequently handed over to his next generations. And in United States, it is for a period of 70 years after the death of the copyright owner, that is the author of the copyright. And there are a number of other intellectual property forms and categories which have emerged in the recent past. For example, domain names. Domain names started when the internet became very popular, and we all started having our own sites. That is, you have a web page which is in the name of www.somecompany.com or .org, .gov. All these things are also protected, because it can also result in some clash between the owners of intellectual property. So company names are all protected, and sometimes the domain names are also subjected to disputes of people who are occupying the domain. They are called cyber squatters. The people occupy the domains and then they sell it at a premium at a later stage. For example, Olympics 2000 wanted to have Olympics2000.com as their domain name. Somebody was already having that ownership, and they had to pay an exorbitant fee to that person who had already registered in the name of Olympics 2000. Sometimes it can be subjected to arbitration, and then it need not be always that you go and occupy that domain, you can claim ownership. For example, governments and big organizations like Oscar or Olympics can always win the case, saying that we are very popular, and so this cyber squatter should be evacuated. This person should be driven out of this site because he is purposely doing it. And in such cases, no compensation can also be provided. So sometimes it is the rights of the owner, because they are very powerful, like government or a big organization, which is some individual with a malified intention has come and occupied that site or that website. Those things can be subjected to arguments and fight in some arbitration court, which is actually again decided by World Intellectual Property Organization. And there are some important goods and services which are provided with a geographical indication tag. It is actually a tag which is giving a particular region of people, region of manufacturers, or the people who are growing such things. They can be agricultural products, there can be manufactured goods, there can be people creating such products through handicrafts or handlooms or cottage industries. They can claim ownership of such intellectual property because they are exclusive to that particular region of a particular country. For example, champagne in France and Darjeeling tea and Tirupati Laddu of late started with their own geographical indication tag, which nobody else can use except the Tirupati Devasthanam can only use, and that is also registered under the category of geographical indication in the same patent office, there will be another division which is looking after all the geographical indications, and they can register your product, and they will protect your product being copied or somebody else using it without any authorization. And for example, Darjeeling tea cannot be duplicated in place like Ooty and Kodaikanal, all these places. They are also having tea gardens. For example, Kunur or Munnar, all these places, tea gardens are there. They cannot put the label as Darjeeling tea and sell it outside. This is one of the best well-known symbols of Indian products in abroad. In number of markets and number of departmental stores, you will find this Darjeeling tea, which is basically grown in the region of Darjeeling. And a number of manufacturers can grow it, and they can have their own brand name and their own symbol, etc. But they will put an additional symbol like this called Darjeeling tea, so that it sells better because it is familiar with the buyers, and then it can sell better in supermarkets abroad. And also we come across traditional knowledge being passed off as some other form of intellectual property. For example, even patents can be obtained for traditional knowledge. Traditional knowledge means we know that turmeric, neem, and other naturally occurring agricultural products, let us say, they are all being used for certain medicinal properties. For example, fungicidal, germicidal, and antiseptic properties. So these things cannot be patented because it is known in the traditional knowledge, and they have been using it for ages in a particular country. For example, in India, we are knowing about the turmeric values of turmeric powder and turmeric use in antiseptic way for hundreds of years. So nobody can claim ownership as this knowledge as a patent. So these things we will see once again when we come across these things in more detail at a later stage. So with this introduction on different categories of intellectual property, now we get into what are the different policies and strategies you should use for startups, for generating, creating, protecting, and making use of the protection to get value out of intellectual property. So now we have covered the introduction. I will pause for 2 minutes, and if somebody is raising I saw somebody raised a hand. I want to answer one or two questions at this stage and then proceed with the other. Arifullah has raised a hand. Can you ask one or two questions? We will rush through because we will be missing some topics if we don't finish it within the stipulated time, but I can answer one or two questions at this stage. So the floor is open for just one or two questions, and we can proceed otherwise.
Yeah, dear participants, do you have any questions as of now? And you may also raise the questions.
I saw a raised hand. So
Yeah, who is raised the hand?
Arifullah. Okay, I think we will proceed.
Yes,
So,
sir. Yes, sir. Please continue, sir.
yeah, in an IP policy of any organization, it can be a small scale industry or a startup, or it can be a big organization, a multinational, which is operating in a number of countries simultaneously. All these organizations, either big or small, they should have a kind of IP policy. So what is your IP strategy? What is your roadmap? It is not only for products and services. You will have all these IP strategy and roadmap. Our management experts and management department people will teach these things to individuals, and those students who are interested in product strategy and product development, they will be talking about the roadmap of a product. What will happen to this product after a certain number of years, and what are the different types of products we are going to introduce in the market. This is a kind of long-term plan, which is IP strategy. Then this is also very important and useful to have an IP-based IP rights strategy and IP rights roadmap to start with in a startup or in a small scale industry or in a big industry also. There will always be a IP strategy and IP roadmap, which will be put into certain kind of process and practice by funding. And if you cannot generate your own IP, you have to scout it. Scout it means bring it from outside and buy from outside, and you build up an IP portfolio. Portfolio is a group of patents or collection of patents. It is not sufficient to have a single patent for a single product or some such thing. There is always a better strategy to have a group of patents for a particular product. A small improvement of the product, a small additional feature of a product can get you an additional patent, one more patent for the same product. For example, if you recall, there was some time back we had one these DVD players. For example, DVD players were in the market, and now they are out of the market because there are so many other ways of playing video and music have come up. So in the DVD player, for example, we had something like 200, 300 patents put together. They will form the technology, core of technology of this DVD player. And it need not be from the same company also. There will be a number of companies independently developing DVD players, and then they will all be contributing to a particular part of the DVD player. For example, the reading head or the motor itself, or for the noise level suppression, and also for faulty DVDs being read properly. All these things are formed into some patents, and then these problems are solved in a number of patents. And all these patents put together will be required for the working of this particular DVD. So a group of patents or a portfolio of patents will be required for a particular problem to be solved, or particular feature of the product itself can have a multiple number of patents. So all these patents will be generating some revenue. Then they will be dividing among themselves, and they will form a consortium of companies, and they will license them out to another persons who are people who are not having the technology. They will be ready to pay certain amount of royalty to take these patents and manufacture their own DVD player and sell it in the market with the permission of the patent owners, original patent owners. Then this portfolio has to be managed properly. There have to be certain decisions taken. For example, whether to continue with the patents. For example, if DVD is almost dying in the market, and it is, let us say, it is no more advantageous to keep these patents alive, then these patents need not be renewed, and they will be allowed to die on their own. The sense that if you don't pay the annual renewal fee, then the patents will be dead, and they will not be applicable, or they will not be enforced anymore. So we have number of patents which can be discarded or allowed to die. So our number of patents will be brought into the portfolio. These are part of portfolio management, and that is also taken. Some decisions are to be taken within the organization or with the help of outsiders who are specialists in that particular technology area or in the particular legal sense. We will be asking them to advise and take decisions based on these inputs. Then we go about commercialization. Commercialization is who is interested in taking these patents and using them? We are only talking about patents, but here commercialization can be equally applicable to even trademarks also. That's known as brand management in the technical parlance. We call it brand management because you can give the brand on lease, and somebody else can make use of your brand value in the market, and they can manufacture the goods and services using your brand, and they will pay certain amount of royalty for using your brand. There are a number of companies who are manufacturing goods and then allowing the others to sell under their brand names. So it is also one way of commercialization. We have seen some of the business development taking place in the earlier scene of, age-old traditional way of looking at making a big dent in the market is by producing a number of products, taking the products to the market, take the income profit and take a fraction of that income and profit and put it back in the R&D. So this is a fueling kind of R&D, and then research is funded enough, and new products and service will be generated and it will be put into the market, or the existing product can be also developed. There are a number of problems which may occur at the time of usage of the product. Then those problems and difficulties can be overcome by producing new solutions through R&D, or R&D can even add some additional features to the product, which are existing products. For example, when the cell phones came, they didn't have camera, they didn't have external connectivity with Bluetooth, or internet services were not provided. So all these are additional facilities or provisions to the same cell phone. Keep on adding one more feature. They keep on adding one more feature, and when you add a feature, some problem will be faced, and that problem will be solved by technical means, and then that technical mean can be technical solution can be 1 minute break. Yeah, I am back. So there was a slight disturbance. Sorry for the interruption. So we have the return on investments sent back to R&D. This is a positive kind of feedback and keeps circulating, and then it keeps increasing your value of the product and market share. And so we can really create a big name in the market and share in the market. We can keep continuing like this, and your business will grow. And there is an additional arm of IPR licensing and know-how licensing which are available if you have products and IPR which are generated. Generated IPR can be actually made use of to produce more revenue by means of licensing out your IPR. That is, your IP rights can be licensed out, and there will be people willing to pay to have their own market share. For example, if you don't have facilities in China to manufacture, then you can give your IPR to Chinese companies to manufacture in China, and they can sell it in their local market, or they can even import it, or they can even export it to a number of other markets where they have marketing capability and presence in other countries.
they can go and do the marketing of your products, which are actually taken based on fee. That is, they have paid a fee to license out your technology in the form of, let us say, patents or trademarks. Then also there is a method of know-how licensing where you give the complete know-how. By giving the patents themselves, you may not be able to satisfy the manufacturing process. The manufacturing process will require a lot of additional knowledge which are known to people who have established the manufacturing process in your own company. So such ideas which are not expressed in patents are known as know-how. So those know-how also can be like what is known as turnkey projects. For example, you just give all the complete responsibility of setting up the entire manufacturing process to a company like, let us say, L&T or some such company who are specialists in some particular manufacturing, say, cement plant. A big cement plant has to be established, and then a turnkey project can be given to a particular company, and then the company can establish the complete manufacturing facility and hand over the key to you so that you go and turn the key, it starts working. That's how know-how licensing can also benefit your organization if you have the know-how, which are not necessarily in the form of patents or trademark, but these things will remain as trade secrets and knowledge within the company, which can be company confidential information. Then we have return on investments, which are going to be additionally giving you some income. So we have all these methods of making money by exploiting or using your IPR, and then we will get a step back and see then what are the various methods or how I can generate IP for a startup. For example, if you have just an idea and you want to have a startup, then there will be a handful of people getting together and trying to establish a startup company. You have to have your ideas clear as to what are the things I can at this stage have them protected in the form of IP. So what are the different IP I am going to generate? What are the ways and means of protecting them? These things have to be planned in advance, and they have to be the plans. There has to be some plans on the anvil, and they keep debating, discussing about all these things. If it is a big or a small organization, any kind of organization for that matter, so it can be involving a large number of top business heads, top R&D heads, and then also the technical personnel, marketing personnel, commercial personnel, legal people, all are involved in generating an IP ecosystem for generation of IP. So we start thinking about what process we can have in an organization, how to generate IP, and then we can throw challenges of these are the problems we are facing in the technical sense or in the marketing sense. We may be having some problems with respect to trademark issues, with respect to copyright issues. All these things have to be evolved, and solutions have to be evolved by discussing among the people in an effective manner. And then if problems are being solved, for example, if inventors are coming up, if the scientists are coming up with inventions, then they have to be rewarded and they have to be looked after. They should not leave the organization and go to other organizations where their knowledge and power can be exploited. So how to retain the people, retain the scientists or research and development personnel, all these things are part of the IP generation ecosystem. So everything is interconnected. So So you have to provide rewards and recognition so that they continue to work in the same organization and give you some meaningful output, meaningful IP generated and protected. So we have seen there can be a handful of people working in R&D organizations, handful of people working in business groups. I mean, these marketing people who are bringing very vital intelligence or important information from the market to the organization and say that what are the possible ways this product can be improved, or what are the possible products which are already in the market, which are the facilities available in those products, and how competitors are faring. That is called competitor intelligence. All this competitor information and product information from the market will be brought, and R&D groups will be challenged by means of creating new solutions, new products, or existing problems, new solutions. This presentation by somebody is come. Yeah. I think now the screen is visible. Can you acknowledge?
Yes, sir. Yes, sir. Visible, sir.
Coming.
Yes, sir.
So, with all these inputs, we have to generate IP, and also there will be a small IP group which is generating IP and protecting IP, and they also have to be involved in these discussions, and they have to sit together every month or so, something like every month. I am not particular about any particular time frame, but it can vary from organization to organization. It can be sometimes quarterly, sometimes even weekly when the development is in progress, and there's a lot of input to be assessed and finalized. They can even have weekly meetings, and then each group is challenged to their maximum extent, and they will be asked to solve these problems. IP group need not be from within house. There can be some outsiders coming and advising in IP. There are a large number of law firms who are specialized in IP, that is intellectual property protection. They can come and advise your organization if it is a small organization which cannot afford to have an independent IP group of themselves. They can seek the help of IP specialists from outside. There are small or big IP law firms which are ready to solve your IP problems for a fee. For example, take your invention and patent it and give it back to you as a granted patent. All these things are subjected to certain amount of consultation and money being exchanged from the organization to the outside groups. So all these things will merge together and work together to produce an IP strategy, and IP strategy will be put into some plans, execution of plans will generate more inputs, more problems, more shaping up of your strategy will change, and then you'll start getting it into a cycle like this, and it will continue as long as the company wants to dominate the market and keep a very high market share in the market. These are all very important to have. So we have certain amount of plan and strategy we have seen, and business plan also will be merged with IP plan and strategy, because business will be conducted by people who are in the field, marketing and selling representatives who are in the field. They are going to bring in more knowledge and more inputs from the business side of the product. And then there will be IP plan and strategy in place. There will be some people advising you within the organization or from the top level like CEO to CXO onwards. Everybody should be involved in the IP strategy, IP generation, what all the IP we have, what all the strengths of our company in owning certain IP, and which are the possible ways in which you can deploy and generate some IP for ourselves and everything will be in the form of regular interactions, meetings, updates. Everybody who is somebody who are stakeholders, as they say, all the stakeholders are in the same frequency and they are all talking in same terms with respect to IP generation and with respect to IP rights in that particular organization. So, which is very important for carrying out your business and carrying out your products and selling them in the market and dominate the market so that you command a maximum share of your product in the market. So we have some different topics in which, the research, what is development. Like, for example, we say we do a small R and big D. That means R&D means research and development. But if you keep on doing research and if you don't develop the research into a product which is of no use to anybody, then there are some pure research going on in a number of organizations. For example, academic institutes. They are only doing pure research and they hardly ever think about developing any product. Whereas in DRDO, like Defense Research and Development Organization, for example, they are more into D. They always say we are doing smaller and big D, that is capital D. We are doing more into developing products and we are doing very less research because we just take research, whatever research output available from the market or from the academic institution. We make products so that they can be utilized in the battlefield. Let us say it is used for defense and it is used for even common people. They can be converted to products. That is where the development comes. And then the invention is there in both, in research also and in development also. We can result in products, processes, services, and number of business models which are cropping up nowadays with all these problems which are faced in the marketplace. For example, people cannot go to market and buy things nowadays. So they have been provided at their residence itself. They are packaged and then delivered at their residences. So that involved a lot of new technologies like payment options or different technologies, encryption, decryption, protected payment options. All these things are technical solutions for business models. So number of business models require number of technical solutions. These technical solutions can result in intellectual property such as patents, and they can be protected, and such business solutions which are protected and they have to be licensed out and somebody wants to make use of these things, they can ask for licensing in, out, and various ways of converting your IP into income for the persons who have developed these solutions, those who have invented these solutions. So some of the basic things like how to start an innovation. There are a number of people who are asking these fundamental basic questions. I don't know what is innovation. There are a number of things which can fall in the category of innovation. Implementation of new ideas, solutions, they can be largely grouped as innovation. All innovations may not result in inventions. Innovation is something, a broad-based term, which is at the bottom of the pyramid, let us say, which is actually like a funnel, which is shown in the next few slides. For example, this funnel, which will be an innovation funnel, which is very famous and very often used for defining and generating what is innovation and how to get a final product launched by means of your innovations. A number of ideas will be generated, they will be evaluated, and R&D will be tasked to generate such ideas into products and then test and prove them. That is testing in the lab, testing in the actual field conditions, it will be tested. Then it will be given for testing by common people. For example, if the cell phone is generated in some R&D lab, it has to be given to people who are going to actually use them and then test in their point of view, how problems can be solved, how problems they are facing, how the number of problems can be solved, and then the final product will result. That is launching of product result. So we have generated a large number of ideas, evaluate a set of ideas, and see whether they are fitting into the framework of what you are going to do and which product you are going to launch will be selected. This is a process of innovation, how to make it as a process. Innovation itself will result in number of intellectual property ideas and then intellectual property itself by going through this innovation funnel, evaluation, testing, selecting, and tasking the R&D, getting the output from the R&D, prototype, working model, then actual product. This different stages of evolution of a product. So we have to find that a product is working in the field, it's working in the hands of the user. Then we are going to finalize the product and launch the product in one or two forms. That is the beginning, version 1, version 2, like that. It will keep on improving. And then this process is required to be implemented, whether you like it or not, in any startup. It will be implemented in a very procedural way, or it can be even implemented in a hodgepodge manner. It is not well defined in that process, or procedure is not followed, but it will always be there. This is going to be followed, and it may not be in the same fashion or sequence. It can happen in a very irregular way also, but finally you are going to end up doing all these steps. That is always there. Then how to generate or foster innovation in an organization? Then you can even study the patents. Number of patents are providing new ideas. A large number of patents have expired. Those patents can be made use of for generating products and services and selling in the market without even giving royalty to the patent owners, because the patents would have expired after 20 years. You are free to use any patent. So patent study is advised. Then you study in social networks, and large number of ideas are floating around. People are providing ideas in blogs and vlogs. Also, they are giving a lot of ideas for products and services. We can get some ideas from that. There is a method called TRIS methodology, which is fostering innovation, which will give you ideas about how to improve a product, or conflicting requirements are there in a product, how to face these conflicting requirements, and this kind of tool available in the TRIS methodology. And R&D is challenged and told to develop such products. Whether the R&D can develop it or not, you can even outsource R&D also these days, and then get products and services developed outside your organization by having some proper agreements in place. You can finance the R&D. For example, people give R&D to the academic institutions, then the entire intellectual property output will be owned by the company which is giving money for R&D. So like that, we can challenge the R&D, and then we can employ R&D either in-house or out of your organization. Then you can get your problems solved for your new products or new product solutions. Then IP team also can be employed. What are the problems faced by people? Let us say in this pandemic, somebody came up with an idea of, from a distance, I should be able to find the temperature of a person by looking at whether non-contact type of temperature measurement system, or even it need not be involving a human being also. You just go and stand in front of a camera or IR camera, infrared camera, then it should display your temperature without a human intervention. And also some identification problems, like only with eyesight, only with eyes can you recognize a person with mask on. All these problems are coming because there are some problems cropping up in the society these days. So such problems, you have to take it take them and solve them. Then you will result in a particular product or a service which you will encash and try to have a startup based on that particular problem, particular solution. And there are in this left side you have all these methods, and right side you have all the some kind of solutions available. You can take a lot of open source software available, use them with caution. You can't use open source software in your product and sell it because it is to be given free of cost, and if you are charging for the product, that should not include or involve your software or software development which you have used by just copying open source and using it, and you are giving warranty to the product, warranty or guarantee to the product. Then the open source software doesn't provide you with any warranty or guarantee, so it can result in some breakdown of the system, or it can create some problem for the human beings or people who are using it. Then you are giving the guarantee for an open source software which you have taken without any guarantee. Open source software doesn't come with any guarantee. So all these things you have to take with some caution and approach with caution. Then open innovation is one thing which you can take innovation from any other organization, either with compensation that is paying a fee, or by just taking it free of cost. You can use it with a particular kind of agreement, and you have to exercise caution in all these things. And it's best to acquire IP wherever it is required. You cannot really go and copy somebody's IP. It will result in some kind of damage to your reputation as well as the products in the market. Products in the market can be seized, or the product can be stopped from entering the market if you copy somebody's IP and then release the product with their other IP owned by others. Then the owners of IP can go to court and then stop the product from entering into the market. So all these solutions have to be taken with a lot of care. And a number of ways you can acquire IP. That is, one way is through mergers and acquisitions. Some big companies always acquire small companies based on their IP strength. If they cannot beat them in the market, they will acquire the entire company and become part of the bigger company. That is how these people like Microsoft, Google, and all these big companies are growing. Facebook acquiring WhatsApp, things like that. So you can do mergers and acquisitions and keep the company growing. So it has to be approached with caution, we have seen, for the IP protection. One is protecting your own IP, and also you have to see whether in the form of product or service, whether you are infringing on others' IP. That is, by saying that I didn't know about it is not an excuse. You ignorance of law excuses nobody. So you have to protect yourself and also protect your products from infringement of others' IP. That you have to be very sure that your product is not infringing others' IP. Then you will also require venture capital funding. That time they will ask whether you have protection for your IP or not. What kind of IP you are having and how it is protected. For example, I have already registered for this trademark. I have already got patents applied for this technical solution. Therefore, I can ask for venture capital funding. The venture capital funding agencies will come and ask these questions, whether your IP is protected or not. Then it can increase your validity or increase your value in the market manifold. Just as they say that brick and mortar companies without any IP will be, let us say, valued for X rupees or X crores. Then if you have a bunch of patents, 5 to 10 patents and established trademark and products, established brand value in the market, then your value of that company can increase it by 10-fold or 100-fold also. see the importance of WhatsApp. It was very useful and sold in the market. It has got a brand value. So $18 billion acquired by Facebook. So like that, it increases. Not only the hardware and software people, all those things are evaluated at less amount. With the availability of IP and protected IP, it can multiply manifold, 5 times, 10 times, 100 times the value of the actual hardware and software which you are using in the company. Then it can generate more value than what you have spent on the R&D and also in the IP protection. That is a long-term goal of IP protection. And a number of ways in which IP can be acquired. We have also seen a few of them. Different sources can be scouted and seen. In-house, outsource, number of organizations which are ready to do R&D on behalf of you, and they'll take money based on the number of hours, number of manpower spent. They will charge the R&D, that is outsourcing the R&D itself. Then some companies are ready to sell their own IP in the form of patents or in the form of trademarks, or lease it out. Trademarks or symbols can be leased out, and then you can take those names and then make use of product, make use of your products, which can sell better with the symbol and market brand name available in the market. You can manufacture and sell them, and so that you can command a big share in the market. And open innovation, wherever it is available, you just take it, like open source. You take innovation from outside sources, and also through mergers and acquisitions. And it can be creating or generating values in terms of fully owning it. You can share it. You can have leased it out. You can even lease it in. Then you can outright buy it. There are patents selling in auctions, patents outright sold by organizations, patents given free of cost. For example, Mercedes-Benz is giving all the safety-based patents of their cars free of cost to a number of manufacturers who are willing to take their patents. They will be advertising. These are available on their website itself, that they can take any number of patents which are available free, and they can use it for safety aspects. Whichever patents are meant for safety aspects of the car, they have been giving it free. Like that, so many places you can acquire patents or intellectual property. So we will look at it from what are the patent rights available to a owner. You can commercially exploit, or we can potential of his or her invention can be exploited by giving a free kind of a small fee, that is based on your sales in the market, based on your profit generated in the market. A fraction of that is going to be given to the owner of the patent. So it is better to be safe than be sorry. That's the idea of having this kind of patents which are already available, and they are very much essential for your requirement. Then you have to make use of those patents without having prejudice. That how to escape is not the solution, but how to join and beat the total thing. If you cannot beat them, you join them and pay a small fee, and then become a partner to the patent owner, and then you can also exploit the market potential and market share. Then you can grow big. That is called freedom to operate. So we have to find what are the patents. For example, in startup, what are the things you should think about? Initially, patents are important. What are the patents I can generate? Technology solution. If I cannot generate, can I acquire some other companies? Then I must go for trademarks, that is by registering trademarks and seeing that I am not infringing on others' trademarks or copying others' trademarks or even passing off or resembling others' trademarks, you have to be careful, because when you grow big, then the other people who are having similar trademarks or which are somewhat identical, then they will come and stop you from growing in the market. So it's better to take care of it in the beginning itself. Then what are the things to be copyrighted within the organization? You have to keep all those things copyrighted, vendors list. All these things are certain things like vendors list, customers list, and their retail shoppers list. All these things can be kept as secret and accessible only to few people. They can also be classified under trade secrets, and they have to be handled accordingly. Because if you go for trade secret protection, they will ask these fundamental questions like whether it was known to everybody that it is a trade secret, and they have been given sufficient training in handling this trade secret. They were always kept under lock and key with some encryption, decryption, or some kind of password protection, etc. So all these things have to be taken care of in the beginning itself. What all things to be declared trade secrets, what all things to be known to only a few people, handful of people, those will be warned against talking about it even in customer interactions or even with retail sellers interactions. You should not tell certain things. All these things have to be trained. The right type of training should be given to the employees and top executives of the company. And then every stage of product development, we have to take care of IP holdings, IP generations, whether you require IP to be brought in from other organizations. Then all these things have to be continuously processed, continuously taken care of, so that you are protected and also you are free from any problems at a later stage when you are growing into a bigger company. That time there will be a lot of objections from other companies for intellectual property aspects. So you have to take care of all these things at every stage of growing. That is, every stage of product development, every stage of growth. You have to come back on the discussion table and you have to bring all the information available and discuss it out. Take some technical help, take some IP help. If you cannot have IP team in-house, you can hire IP lawyers and IP specialist firms from outside, and they can be willing to do all the give you all the advice for a fee. So you should not hesitate to think about it. It's the most neglected area. Once again, I'm telling you this. People say when it comes to that point, or when we have to cross the bridge, we will cross it. That sort of attitude is there, which is very dangerous and which is very beyond certain level which goes, then the entire business can be closed. There are a number of examples in which businesses have closed down and business had to pay a large amount of compensation to the IP owners, rightful IP owners. Then the business itself will be wiped out. So we don't want any such thing to happen to a startup or for a small scale industry. So we have to be very careful about freedom to operate. By both ways, you have to check whether I am doing it properly or not, whether I am protecting my own IP, whether I am infringing on others' IP. All these things have to be taken care of at every stage. So I think we are running out of time. What is the time limit? Dr. Ramesh, can I
Sir,
take
actually,
a few minutes?
actually, the time is over. So now the time is
Over. Okay.
12:40.
So
So
we will
please
stop
finish
here.
it.
I think I have covered all the topics, and I will go to the conclusion, and
Yes, yes, sir.
we will give 5 minutes for
Yes.
question and answer session.
Yes, sir. Yes. Please, sir.
So these commercialization models, I'll touch upon them for 1 minute. That is just about various ways of commercializing IP, which is licensing out, cross-licensing, trading for shares, joint ventures. All these places, IP owned will help. If you are owning a lot of IP or valuable IP, these things will help in getting loans, mortgaging them, and getting loans. Like shares, you can mortgage them and get money. And you can collaborate with big companies or collaborate with equally sized companies or partnership with other companies. Then while also dealing with customers and suppliers, you can commercialize on the basis of your IP. So these are not really required on military F5. Yeah. So what we understood is that R&D feeds on creativity and innovation. That is, R&D has to be properly managed, handled, and it has to have inputs from business as well as from technical people, and also from IP generation. They should get support. R&D should generate IP, and they should be protected by IP groups, either from inside the organization or outside. Innovations have to be taken care of. They have to be generated and they have to be converted to IP in a proper strategy. And then the process should be in place. So nobody is following processes as it comes. When it comes, we will do it. Kind of attitude should not be there. That will result in some dangerous situations in future. If a company is growing, these are all indicators for growth and also for the protection for growth. Otherwise, you will be cut to size by some bigger companies will come and ask for IP compensation, and then you will not be able to grow beyond certain level, or you will be made to pay a lot of compensation, which will hurt the company. And then we have seen how to generate, how to get IP from outside. It's better to pay a license fee and then get IP or patent rights from other companies rather than simply copying it and getting into a grief situation at a later stage. So it has to be at regular intervals. You have to keep on revising it and keep on reviewing it, what best we can do for protecting your IP and also to generate as well as bring in IP from outside sources. They have to be constantly explored and kept on, assessing, arguing, discussing, and then decision making. All these things are part of IP generation, protection, and IP leasing in bringing from outside the organization. So I will leave here and open the session for a few questions. Open the platform for a few questions from the participants. They are interested in particular doubts they want to clarify.
Yeah, dear participants. Yeah. Hello, Manan sir.
Yes,
Dear participants.
I can't hear you.
Yeah, dear. Raise your questions. Now the session speaker is ready to answer your question. Any doubts, any questions regarding to IPR? First, any more questions from your end? Not there, then we'll go to close the session.
Okay.
Now request the participants please give any feedback. One or two. Dear participants, so please give the feedback on the session. Hello, am I audible? Hello? Am I audible to you all? Hello? Sir, Manu sir, am I audible?
I can hear you. Yeah, I can hear you, and
Yeah.
participants can also hear you.
Yeah, no one is not giving
Nobody
response.
is
That means
talking.
I
That's
am connected or disconnected. I was a little confused.
either
Yeah,
they have
dear
all
participants,
understood
please
or they
give
have
any one
not
of you
understood.
give the yes, sir. So please give the feedback on the session. Any one or two. So okay, sir. Shall we go to close, sir? Manan sir?
Yeah. Okay.
Yeah. So thank you, sir. Thank you for giving a wonderful session to us. People they understand very easy what is a IPR and how IPR it is supposed to startups. And you are giving the very brief about of IPR and you can understand very easy. So hope we are expecting to reach the participants, right? So participants also get very good benefit from your session, sir. Really, we are very thankful to you, sir, for giving the wonderful session to us. And also, we are thankful to you accepting our request when we are requesting to you. And without hesitation, without lapsing of any kind of thing, then you are accepting our request. So once again, we are very thankful for your kind consideration and taking the wonderful session to us. So thank you, sir. Thank you, Nanda. So dear participants, please submit the feedback form. Those who are submitting only, they will receive the certificate. So certificates will be issued to you all. So after 2 days, we are working on it. Okay. So any more doubts or clarification, and you be stay in WhatsApp group, and you can also approach to me, the coordinator. Right. Further any queries or further the information, and you can also approach the coordinator. So thank you, sir. Thank you, everyone.
Okay, Ramesh. Thank you very much. Thank you, participants.
Thank you.
Will
Thank you.
I hope you have benefited. Thank you very much,
So you are
all of you.
spending a great time, sir. Great time with us.